A very warm good morning to all of you. Yeah, Mr. Ahtasham, I formally welcome you. Good morning. Today I propose in this particular engagement the idea of temporary protection, temporary complementary, subsidiary, and other forms of protection. I mean the refugee protection and the future of international protection for refugees and forced migrants under international refugee law. In this particular engagement, we are going to critically appreciate the concept of temporary protection, particularly the refugee protection in the situations of mass influx, how to determine the prima facie status of refugees, what is the idea of temporary asylum, what could be the grounds of temporary asylum, and how the idea of protection has been appreciated under international refugee law. What exactly are the contours of a relationship between temporary protection of refugees and how does it differ from the subsidiary idea or the subsidiary protection of refugees. There are certain important instruments, and these instruments must also be taken into consideration while critically appreciating the idea of temporary protection in this particular engagement. There are UN guidelines on temporary protection or stay arrangements, 1967 UN Declaration on Territorial Asylum, and the mandate that has been incorporated under this particular declaration we have to appreciate. Thereafter, we have to evaluate the Convention Against Torture of 1984. We have to undertake certain important guidelines envisioned by the Amnesty International on temporary protection of refugees. We have to undertake and appreciate the work that has been done by the UNHCR in the form of handbook of UNHCR on temporary protection, and the work that has been done by the UN Office for the Coordination of Humanitarian Affairs, guiding principles on internal displacement, that has to be taken once again under consideration while appreciating the idea of temporary protection. And we should not, of course, forget that there are certain important articles of the 1951 Refugee Convention, and these articles must also be exclusively appreciated, particularly the Article 5, Article 8, and Article 9 of 1951 Convention relating to the status of refugees. There are, certain important cases as well. So far the case law is concerned, then we have to understand the case of the Tahir Hussain Khan versus Canada. There is another important, decision that has been delivered by the European Court of Human Rights, and that is Chahal versus United Kingdom. Then another important, decision on the temporary protection while appreciating the contours of the idea of refugee protection in the form of temporary protection. Then the Attorney General versus Ward, that is another important, decision that has to be taken into consideration. Then another decision is of, Howard versus Secretary of State for the Home Department, that must also be taken into consideration. Now, my dear friends, we have to appreciate the idea of temporary protection. What exactly are the criteria of temporary protection? How this idea of temporary protection has been visited by the United Nations High Commissioner for Refugees. But before I proceed with the idea and understanding of the temporary protection, I must also try to bring in your kind information that there are certain important developments in the past, particularly in the form of refugee exoduses, particularly in certain important time frames. Suppose 1914 up to 1918, a period of 4 or 5 years. We have to understand how and under what circumstances the idea of temporary protection was extended to the Belgian refugees. Then in 1920s, there has been another what we call exodus of refugees, which is popularly known as the Russian and Armenian refugees. Then again, we are also having in 1930s up to 1940s Jewish refugees, how they have got the temporary protection and what kind of a treatment was meted out to them by the international community of nation states. Then in 1940s up to 1950s, Eastern European refugees and what kind of a protection they have been provided with. Then from 60s, 1960s up to 1980s, Vietnam, Chile, Ugandan, Asians, Eastern what we call European refugees, and what has been the response of the international community of nation states when there was a question how to protect, how to extend idea of protection to these refugees. Then from 1990s onwards, we have witnessed how the protection, particularly whether it was the temporary protection or prima facie protection, subsidiary protection, permanent what we call protection, or any other form of protection, how these Kosovans, Somalians, Iraqis, Iranians, and people from what we call of Sierra Leone and other important what we call, or particularly the Congolese refugees were treated. In addition, along with Ethiopians as well as Rwandan refugees. Then another important journey of refugees, or another important phase of refugee protection, that it starts from 2000 and goes up to what we call last year, and that is a period of 20 years, that is from 2000 up to 2020s. What kind of a refugee protection has been extended to a particular class of refugees from multiple what we call nation states, like from Afghanistan, from Syria, from Iraq, from Myanmar, from Somalia, from Congo, and including what we call Mexico, and the latest addition happens to be of Venezuelan refugees. Then this entire gamut, or this entire international refugee law argot has given rise to certain important questions. So what are the potential questions which we must try to understand? Then there is a complete list of what we call of questions, and these questions must also be attended. Suppose, how powerful is international law in the field of refugee protection? This is a very, very important question that must also be taken into consideration. Again, what are the grounds for temporary protection in international refugee law, and what has been the state practice, and particularly the South Asian state practice with regard to the temporary protection? Then there is another important questions: how to appreciate the relationship between temporary protection, subsidiary protection, and prima facie refugee status. Then how to identify the main strengths and weaknesses of the current international regime in ensuring implementation. Are the concepts of the temporary protection and the safe havens supplement or substitute for refugee protection as traditionally it has been conceived? What is the future of the refugee protection? Can we think of humanitarian law, refugee law, and human rights law as three overlapping circles of international protection for victims of conflict, persecution, and oppression? What are the significant, my dear friends, significant differences or potential tensions between the three frameworks, and how might they complement or reinforce one another. But at this stage, while addressing this particular question, my dear friends, we should not forget what exactly has been the contribution in the last, particularly 2 years of the Global Compact on refugees and migrants. That should not be, forgotten. That should also be taken into consideration while appreciating the future of refugee protection, particularly within the, architecture of the three important, frameworks, that is international human rights law framework, international humanitarian law framework, and international refugee law framework, along with some of the important what we call provisions taken from the international maritime law, international constitutional law, comparative constitutional law of the SAARC nations. So that should not be forgotten, as we have deliberated some of the important what we call dimensions of the constitutions in the previous what we call engagement. Another important question, or not exactly the question, but rather in the form of some kind of understanding, and that is protection or deterrence. How to what we call appreciate these two important paradigms, and these two important paradigms has also given rise to certain important questions. What other options exist? That is the very first and the most fundamental questions. Are the concepts of the temporary protection, my dear friends, and safe haven a supplement or some kind of a additional what we call or additional deliberations required? Then what new global problems, my dear friends, impinge on current models of as well as the frameworks of refugee protections entail? And definitely we should not forget, my dear friends, the results of a freer market as asylum seeking can only be what we call guessed at. What other alternatives are there? Are environmentally displaced persons should be what we call addressed as refugees. Under what kind of a protection that has been contemplated under the United Nations Framework Convention on Climate Change of 1992, are they legally entitled to international protection if taken together? Then there are certain important what we call debatable dimensions which I would like to place for your consideration, and we must what we call mull over. We must try to appreciate those very fundamental considerations. Suppose 1951 UN Convention relating to the status of refugees with its additional protocol of 1967, my dear friends, as well as other associated related standards may be seen as a critical elements of liberal internationalist aspirations. I am emphasizing this particular expression, that is critical elements of liberal internationalist aspirations for universal human rights or universal human rights protection, whatever may be the nomenclature, particularly that becomes relevant in the post-Second World War era. So how we are going to attend this particular dimension, to what extent we should incorporate, we must critically appreciate and incorporate within our national protective shields, which we are contemplating for refugees through what we call our highest legislative bodies. To what exactly should be the contours of the critical elements of liberal internationalist what we call model, and how the aspirations of the refugees are likely to be satisfied? That should also be taken into consideration. Another important consideration that requires our collective attention, and that is again relating to the standards which are based on the principle that justice as a dimension of citizenship rights. So how to do justice with a democratic citizenship, with an idea of what we call of dimensions of citizenship rights? So what what exactly are the citizenship rights, and to what extent we can curtail those citizenship rights that are also be taken into considerations, because this particular dimensions, my dear friends, needs to be extended to a global sphere rather than remain confined within the boundaries of a nation state. So this should also be taken into considerations. Otherwise, we would not be in a position to do justice with the idea of democratic citizenship. Then there is another important dimension, and that is globalization. How the globalization has impacted, because the globalization, my dear friends, is seen to have shifted the role of the state. It has created a katana of challenges to its power from global markets, intergovernmental organizations, and NGOs, at the same time undermining microeconomic management, thus increasing the public insecurity, my dear friends, and reasserting of the politics of the border. So it has generated, globalization has paved the way for the generations of the border, the border politics. So how we are going to these aspects, because the border politics has also generated and weakened the idea of the border justice. So how to create some kind of a reconciliation between these two important dimensions. But at the same time, my dear friends, we should not forget that the attempt by the Western governments to deter, to detain and deport those entering through the back door is seen by some as a move away from a right-based international, or right-based what we call liberal internationalism, towards exclusionary nationalism, or a particularist what we call internationalism, which redefines asylum as a political what we call benefit, as a political what we call brownie pound bestowed by the host state, rather than a human rights involved and accessed by the individuals irrespective of their mode of what we call entry. So how to create a balance between particularist internationalism on one side, on the other side it is the right-based liberal internationalism. How to create a balance between the two important what we call ideas. So these are some of the important what we call dimensions, and particularly we should not forget that in the post what we call UN Global Compact on Refugees, how to attend these two important what we call understandings or paradigms or narratives. One is known as rights-based liberal internationalism. Another one is which is known as particularist or exclusionary what we call internationalism. So how to what we call assess, because we should not forget that we should try to assess these two important paradigms within the rubrics of what I call comparative international law. So how to what we call attend these important dimensions, and how to appreciate the impact of these two important approaches. Then again, I am taking you back to our initial derivation, and that is temporary protection. What do you mean by temporary protection, my dear friends? Before proceeding further, may I have your input on this particular aspect? Yes, Mr. Ehtasham Sahib, my dear friend. Are you there? Sure. Mr. Jamshed Ahmed, are you able to listen me? Am I audible to all of you?
Yes, sir. Yes, sir. Yes, sir. Yes, sir.
Okay. Okay. Thank you. Thank you. Because there was a strip on my screen that you got disconnected.
No, no, sir. I'm listening.
Okay. Okay. Thank you. Thank you. So, what is your understanding, my dear friends? Yeah, Mr. Vikash Kumar Sharma.
Yes, sir. Good morning.
Good morning, brother. How do you perceive the idea of temporary protection?
Of refugees, sir.
Yeah, sure.
Mm, what can I say, sir? In context of India, the temporary protection is in the contemporary times. It is the institutional protection is very weak, and uh, uh, there is no such interim type of interim, even the interim reliefs which are being given by the be it executive or the judiciary. So it is very dismal in context of India in this time. Like when deportation is going to be happened, temporary protection would entail that it should stop uh, at the moment a petitioner reaches the court and convinces that there is a threat to his life or her life in the country of deportation, as has happened in context of Myanmar. So these are one of the main ideas of the temporary protection.
Yeah. Thank you, brother. Yeah, Mr. Imran, you have raised your hand. Yeah, Mr. Mohammed Imran. Well, I think I am not audible to Mr. Mohammed Imran, but meanwhile, I have also received an
Audible now?
input. Yeah, I am audible. Am I audible to you?
So, hello,
Yeah, Mr.
sir,
Imran.
can you hear? Okay.
Yeah,
So, sir,
hello.
I was saying
Yeah,
that
please.
temporary protection with reference to refugees is a immediate protection that is given to a group of people who have been forced to leave their state of origin or somehow who have migrated from one place to other places, and of course the status is before it can be decided that they are actually refugees or not. I mean, the I think that the whole the idea of temporary protection started in 1990s when the mass influx of refugees started gaining momentum, especially in case of Kosovo and all. So but that time I think it was really a good idea. But again, in case of South Asia, which specifically with reference to India, I think the idea of temporary protection has taken a very bad shape. For example, if you see in Assam, the protection were given on an emergency basis in 1971, and right now it is possible there were many people who might have migrated in 1970 onwards, but even after living for almost 50 years, uh, they're the next generations are facing the problem of, I mean, they will be facing problem in the state of Assam because of you know because they were neither recognized as full-fledged refugees nor full-fledged citizen, but because they lived almost for 50 years, they don't have any association with Bangladesh also. So, I mean,
Yeah,
particularly in case of India, Bangladesh, the situation is more complicated than in Kosovo and other places. But per se,
yeah,
the idea of temporary protection, I personally feel that it is a good idea. I mean, you can't wait someone to give the status of refugee to protect them. So that is, of course, a good idea. Thank you, sir.
yeah. You're
Sir,
welcome.
hello.
Thank you. Yes, ma'am.
Yeah, so
Please, Miss Pooja.
I think that temporary protection is a kind of protection that is granted to a person when they move to the other part of the other countries. So basically, the idea of temporary protection is appreciable because it helps to protect the human right immediately of the person who has been displaced from their country. But I think if we want to have a solution of the refugee issues, then the temporary protection alone is not sufficient. One should also focus on solution based approach, because for the time being, temporary protection can ensure the human right of the refugee, but it may not be as effective as one should get when focusing on the solution based approach. And also, sir, I found the some state has adopted a discriminatory approaches even while conferring a temporary protection, because generally
Yeah.
when they confer a temporary protection, they protect just a very few fundamental rights, like right to life. But what about their right to education and other rights? So I think it's a good idea, but it requires some reform so as to make the protection of refugee more effective.
All right. Yeah, very true. Very true. Very true. Thank you. Well, I have also received a very, very important input from Mr. Ehtasham. As per his understanding, he is of the view reaffirmation, temporary protection is the reaffirmation of the basic human rights to return home in safety and dignity, and for an end to all practices and actors which force people out of their homes. Pakistan, as per his homeland, it's best for doing the same with the Afghan refugees and the Rohingyas. As well as so far the latest developments are concerned, Mr. Ehtasham is of the view that the Pakistan is equally offering the COVID vaccination to all manageable refugees registered with the government of Pakistan. So this is what he has also, pointed out, that in such a situation, temporary protection is of vital importance, and it has rightly been, pointed out by the, and that is going to be the majority understanding. But my dear friends, I do concur with all of you with the varied, what you call, approach, and I really appreciate your point of view, particularly Ms. Prakriti Malla, that the solution-based approach, should be there, and this has been one of the most important contribution of UN global, compacts. And Mr. Imran, you have rightly pointed out that it is indeed a very, very important and good idea, because in emergency situations, with a sense of immediate, what we call, relief, and that should be extended, particularly in situations of the mass influx, as you have, pointed out. So that should also be, taken into considerations, and an idea of what we call, interim relief. My friend has also, pointed out, Mr. Vikash Kumar Sharma. So together, at least, we are in a position to appreciate the different contours of the idea of the temporary protection. But at the same time, my dear friends, so let me put it like this. So far, the idea of, temporary protection is concerned. Refugees, my dear friends, are inherently temporary, and their status as refugees exists to bridge the gap triggered by a collapse of the, natural national bond between citizen and the state. So temporary protection functions as some kind of a, temporary shield, a temporary shield just to bridge the gap that has been, what we call, warranted and necessitated due to the some unholy, circumstances. Refugees, my dear friends, seek temporary protection in another state, restored. But at the same time, my dear friend, we should not forget, it may be either with the, what we call, country of nationality, or with the, third state. So that should also be taken into consideration, because the idea we are supposed to take into account even the idea of, internal displacement, and how internally displaced persons generally treated by the national governments when there is a requirement of, temporary protection. Temporary protection, therefore, is, I think, metaphorically speaking, temporary protection akin to immediate or emergency medical first aid to refugees upon their hitting the land of the reception in the absence of what we call of, full. I'm also coming to Mr. Saijit. I will attend your observation as well. So, as per my understanding, I perceive the idea of, temporary protection as an emergency medical aid kind of, relief. So that relief should immediately be extended to the what we call, people, because in the absence of full protection with a wide range of rights and benefits under 1951 UN Convention relating to the status of refugees in the mass influx situations or otherwise have also been contemplated. Therefore, temporary protection is a situation as we contemplate that in case of trauma, in case of medical emergency, immediate medical relief is extended. So therefore, to claim temporary protection is an inclusion, a kind of inclusion in a host what we call territory, country, or what we call community as a consequence of exclusion from national protection of the territory, country, or community of the state of origin or the state of homeland. This should also be taken into consideration. And my friend Mr. Saijit is making an observation that theoretically temporary protection is sine qua non of entire refugee law regime based on responsive and remedial action. It aims at providing humanitarian aid. Absolutely correct. And I am immensely thankful for your contribution, Mr. Saijit Singh. Yes, theoretically speaking, and not only the theoretically speaking, but I am of the view that even practically this is the most important requirement, because what is important in an emergency situation where the state institutions are confronted with a mass influx situation, where the mass exodus is there, where massive what we call movement of people is taking place, as we have recently what we call seen, and that is in case of Mexico, at the borders of the United States of America, in case of Venezuela, in case of what we call of the Rohingya refugees since 2012, and that got aggravated on a massive scale in 2017. So these are the fundamental what we call situations. Two situations are from the Latin American countries, and one situation which I have mentioned before you, that hails and that belongs to the South Asian what we call refugee map. So these are the different what we call situations, and if we collectively draw some kind of a analogical deduction in understanding the idea of temporary protection, then it becomes a temporary relief, an emergency what we call situation or emergency, and that is why solution based approach is the requirement, as it has been contemplated in the UN global compacts, and that is why it is generally appreciated as a very, very important and good idea, because the temporary protection is a backup to the full what we call protection one expects from the state, that come into play only in situations or in the situation when such protection of the country of origin is not at all available. And that is why the temporary protection, my dear friends, is a continuation of insecurity and deprivation of rights and benefits outside the 1951 Refugee Convention. And therefore UNHCR, my dear friend, has released a very, very important note on this particular aspect, and that note should also be taken into consideration. It is a important what we call UNHCR on international protection. It has been issued by the United Nations High Commissioner for Refugees in 1994. And in essence, my dear friends, temporary protection was conceived as a return-oriented protection mechanism, and this should not be forgotten, because within which the focus, a return-oriented protection mechanism, within which the focus on return is the most appropriate solution, provided the rationale for standards of treatment which emphasize the provisional aspects of the refugees stay and minimize, at least in the initial stage, efforts to promote integration. So, my dear friends, this particular note of 1994 issued by the UNHCR basically takes into account some important elements. Out of this particular paragraph, number one element is a return oriented protection mechanism. That is one. Second important element which I have called out of this particular note of 1994, that is standards of treatment which emphasize the provisional aspects of refugees. So this should be taken into consideration. Another one is, and that is the what we call last one, minimize efforts to promote integration. So basically it gives some kind of a semblance of security to the host state, that there is no requirement of having a full-fledged integration of, in the name of the temporary protection of the new arrivals as refugees in the host state, because it minimizes the governmental efforts to go for any kind of integration. And that is why, if you take into account further, then it is also contemplated in the same note of 1994 that a broad what we call consensus on the need of to provide temporary protection, including asylum, on at least a temporary basis to refugees forced to flee war on serious what we call civil disorders, as well as to those fleeing persecution, and suggest to this and the adoption of the guiding principles embodied in a global or regional what we call declarations. This should also be taken into considerations. Therefore, my dear friends, if you take into account this entire what we call the semantics of this particular note, and that is of 1994 note on international protection issued by the UNHCR, then it takes a very, very symptomatic language, is symptomatic what we call argot, or some kind of a what we call if you take the entire lexicon, then it is symptomatic, and it is full of ambiguities which endured throughout the decade regarding the personal scope of the temporary protection. Because the UNHCR would resume or recommend a non-binding declaration to address the needs of refugees fleeing persecution, is to say the what we call least, or given that these refugees fall within the scope of the 1951 UN Convention relating to the status of refugees. Because if you take into further, let me put it like this: if we ask a very simple question, what is temporary protection? As I have, and majority of the students have, responded to this particular, aspect, and it is of vital, important. My dear friends, the concept of temporary protection has evolved in Europe and other what we call, regions as a provisional protection. And at this stage, let me clarify. If you study a very, very important what you call directive, and that is known as the qualification directive of the Council of Europe, or which is popularly known as the European Council's qualifications directives, and its Article 9 subclause 1 and 2 of this particular article, you will find what exactly are the contours of such kind of a protection which is available to the refugees. Therefore, my dear friends, the concept of temporary protection got envisioned in European what we call circles or in European lands and other regions as a provisional protection. Temporary protection is also being categorized by many other important jurisdictions as a provisional protection. And we should not forget, my dear friends, Article 16 subclause 2 of the German constitution as well, because they have recently amended this particular provision of the constitution of Germany. So they have also contemplated the idea of what we call the temporary protection, and we find in Germany interchangeably they use the temporary protection with the idea of law of asylum as per their constitutional understanding. So therefore, the concept of temporary protection, which got concretized in European what we call lands and other regions and other jurisdictions, categorized it as provisional protection, response to situations of the large scale, what we call, displacement, as my friend Mr. Imran has also, pointed out. And basically, when we are, talking of, large scale, human displacement and human migration, which is generally generated to a, significant extent by the compelling reasons, including or akin to what we call those in refugee definition as per 1951, what we call, convention relating to the status of refugees. Now, there is another important, dimensions to it. What is the purpose of, temporary protection? My dear friends, the purpose of temporary protection is to ensure immediate access to safety and protection of what we call, basic human rights, including protection from refoulement. In majority of the nation states who are what we call, the refugees in many jurisdictions affected by the large scale what we call, movement of people. Temporary protection may also be, my dear friends, may also serve to enhance prospects for a coherent regional response beyond what we call, immediately affected areas. For example, take the case of, Rohingya refugees in India, or the Tibetan refugees in India, Chakma refugees in India, Tamil refugees in India, Chin refugees in India, Hojang refugees in India, Afghan refugees in India, Shia refugees, Tajik refugees in India, Syrian refugees in India. And you can also what we call, replace and substitute the word India in this entire, categorizations. Rather, you can also what we call take into account the refugees in Pakistan, refugees in Nepal of the Bhutanese what we call, origin. You can also, take into account other, classes of refugees in all the, South Asian jurisdictions, bearing few like what we call, Maldives. So we are having extra South Asian human displacement and migration, but at the same time, we are also having, my dear friends, intra-South Asian refugee movement. So the temporary protection is of vital importance. Even in other what we call, regions, at regional level particularly, UNHCR, my dear friends, the Council of European Union, which is popularly known as the EU Council, the European Council on Refugees and Exiles, ECRE, and other important what we call, organizations and refugee advocates generally align on the optimal what we call, scope, use and characteristics of the temporary protection programs. So temporary protection is not a new idea, and it is not going to be a novel idea for South Asia. Many other what we call, regions, many other important, jurisdictions, national jurisdictions I am talking of, they have been subscribing to the idea of the, temporary protection to refugees, because the temporary protection, my dear friends, is generally associated with protection of limited duration and standards of, treatments lower than those which have been contemplated and envisaged in 1951 convention relating to the status of refugees. Therefore, when we are, talking of the temporary protection has got limited what we call, duration. Standards of treatments are not the full-fledged standards of, treatments as per the prescription given by 1951 convention. In some mass influx what we call, situations, the Refugee Convention of 1951 have been suspending pending the resolution of the, cause of such important, movement. UNHCR has both acknowledged and called for temporary protection in the situations of the mass influx, including in respect of, my dear friends, of state parties to 1951 Refugee Convention, and thus for the persons who would customarily benefit from the convention protection, whatever the protection has been contemplated, particularly Article 5, Article 8, Article 9, Article what you call 32 of 1951 Convention relating to the status of refugees. Because the Executive Committee of the UNHCR, my dear friends, recommended temporary protection as the minimum protection every asylum seeker should receive. So that is the most minimum continuum of protection. If you take into account all the temporary protection programs, then it is the basic and the most general understanding among the stakeholders that the temporary protection program should not be used as a substitute to refugee status. As a refugee status, it should not be used. Why? Because it may delay grant of refugee status, or to deter and deny entry to those seeking protection. Therefore, my dear friends, a temporary protection programs should be used to safeguard persons who are in substantial danger or substantial peril, or those who have been substantially imperiled, and who do not need, or who do not what you call meet the refugee standard, or who cannot avail themselves of the refugee determination status procedure. Therefore, my dear friends, even European Council Directive on Minimum Standards for giving temporary protections conceives of temporary protection as a procedure. As a procedure, I am emphasizing this particular point. Temporary protection has been envisioned, conceived, and formulated by the European Council as a procedure to use in situations of mass influx or imminent mass influx, particularly if the asylum system cannot process the influx without adverse effects for its efficient operation. And this is the mandate, my dear friends, which has been contemplated under Article 2, subclause A of the European Union directive. So regionally speaking, Europe is a region, my dear friends, that has contemplated all these situations. At regional level, they also came out with some kind of a mechanism for extended protection to refugees on temporary basis. Therefore, the word temporary, in fact, might better be characterized as an impermanent. And for this particular reason, my dear friends, European Union required that the beneficiaries of the subsidiary protection receives roughly equal treatment to refugees, as that has been contemplated by the other stakeholders. Therefore, a long-standing question provoked by the granting of temporary protection instead of the convention rights in such situations, particularly the mass influx situations, whether states parties to the 1951 Refugee Convention can justify. Justifying what? As a matter of law rather than pragmatism, regarding suspending convention rights to asylum seekers and or refugees in a mass influx situation. Will it be a possibility? Even though the 1951 convention, my dear friends, does not include a general derogation clause equivalent to those in international human rights, frameworks or treaties. It is generally argued by many scholars, my dear friends, that two provisions of the 1951 convention, that is Article 8 and Article 9, to a very limited extent, does contemplate the idea of derogation. In the alternative, my dear friends, it is posited that via subsequent agreement of state parties, implied derogation allowing for temporary protection in mass influx situation is now an accepted feature of the convention regime, 1951 convention regime. So idea of temporary protection has always been, there. But how to what you call, contemplate, how to envision the idea of, temporary protection, particularly in those jurisdictions which are not privy to 1951, convention, or those countries who do not wish to accommodate the mandate given by 1951, convention, despite the fact that they have also become the party to to 2018 UN Global Compacts on, refugees. Because it is in the DNA of the nation states that the nation states are always shriving from their, responsibilities. They are not interested to perform their responsibilities under international law. And that is why, or rather I should say, I should, put it like this: since 2018 UN Global Compact on Refugees has been contemplated as a non-binding instrument, which is legally not binding, then majority of the nation states have immediately acceded to its mandate. Because any kind of accession or signature does not contemplate or does not entail any kind of accountability, transparency, or responsibility on the part of the nation states in case of any kind of a non-implementation of the mandate that has been contemplated under these two global compacts. But since 1951 UN Convention relating to the status of refugees is an instrument that contemplates responsibilities, if a particular geopolitical entity has become privy to the mandate of 1951 convention, then they immediately become accountable to the community of nation states, to the global community. In such a situation, what is there for the protection of refugees? Then it includes, my dear friends, the idea of temporary protection as well. Therefore, in recognizing the legal power to derogate from convention rights in mass influx situation, there are limits on derogation under international law, and these limits equally apply to derogation under 1951 UN Convention. And UN, or rather 2018 UN Global Compact on refugees and migrants are not the only soft law. There are other important soft laws which also contemplated the idea of temporary protection. And it is conclusion on the provision on international protection, including through complementary form of protection, that has been what we call it's a conclusion issued by the executive committee of the UNHCR in 2005. There is another journal conclusion on the international protection that should also be taken into consideration. Again, it is going to be the EXCOM what we call conclusion, or executive committee what we call contemplation of 1994. Then there is another important dimension to it, my dear friends, and that dimension which has also contemplated the idea of temporary protection, which has been provided protection of asylum seekers in situations of large scale influx. Again, it has been what we call, adopted and issued by the EXCOM conclusion in the year 1981. Then there are, another important what we call, stage that has been provided and given and shaped the idea of, temporary protection. It is UNHCR documents, case laws, regional courts, what we call, produced case laws, national jurisdictions produced case laws, regional arrangements, national legal, the legislations, and the juristic writings have also contributed a lot of what we call, debate that gyrates around the idea of temporary protection. So at this stage, my dear friends, if you take into account the entire gamut of our deliberations of today, then these deliberations have generated a debate, and there happens to be a central debate, and the central debate gyrates around certain fundamental questions, and these questions I have framed, and let me what we call share these questions with all of you. And these are the questions which basically taking into consideration the idea of the central debate on temporary protection. Number one, I have conceived as many as 6 important questions, and I will share those questions with all of you. And some of the questions may also be the part of what we call of the of your end-term examination. Number one question is temporary protection on the basis of group assessment of protection need an adequate alternative to individualized examination of refugee status? That is one question. Second important question is, are there legally binding norms for temporary protection, or is it a matter of discretionary state practice? This should also be taken into consideration. My third question is, what should be the duration of temporary protection, as I have contemplated and shared that there are, what we call less limited international standards of treatment for extend under temporary protection regime. And there is another important dimension to it, and that is that it requires an immediate emergency kind of a if emergency kind of situation is there, then we generally contemplate the idea of the temporary protection. So in such a situation, my dear friends, how we are going to deal with the idea of temporary protection? Then there is another important what you call the fourth question. What level of rights must be accorded to those granted temporary protection? Whether the full-fledged, and who is going to determine whether this range of rights, what kind of rights should be the part of this range of rights? What should be the benefits, and what kind of a categorization of the benefits should be there of this kind of rights which are likely to be made available by the host state in the name, or the people who have been granted the temporary protection or likely to enjoy temporary protection? Another important question that comes to my mind is temporary protection, after all, my dear friends, a useful vehicle for advancing refugee law, refugee rights, or it is going to be a major contribution on the part of what we call of the national jurisdictions in enriching, enhancing the level of protection contemplated under international refugee law? Is it the tool that states need in order to resolve contradictions, to fulfill their responsibilities, to address the what we call gaps in the protection and correct weaknesses or address golden silences in the schematization of international law on refugee protection? In other words, we can put it like this, and that gives rise to another important dimension in a form of a question: can temporary protection, my dear friends, be the basis for a supplant or supplement, or even in a more what we call daring spirit, I should say, my dear friend, a contemporary alternative to 1951 convention? Though in principle I do not agree with my own question, but I dare to what we call contemplate this particular alternative to 1951 UN convention relating to the status of refugees. Is there any kind of a policy? Will it be okay for the nation states to resort to the derogation in situations of the mass influx, in situations of the protracted refugee crisis, in situations where the persecution is apparent? So how to deal with these particular aspects? We must be aware of all these kinds of circumstances. Then what are the focal points? What are the points of contention? What is the bone of contention? My dear friends, we can collectively put it like this: temporary protection as an administrative measure until individual examination is carried out or group recognition occurs. Every individual in a group should be treated under temporary protection. Because I feel, and it is another important focal point, temporary protection is a precursor. But remember, it is not an alternative, my dear friends. If I am saying it is a precursor, precursor to what? Precursor to 1951 Geneva Convention on Refugees. But it should never be formulated, it should never be treated as an alternative to 1951 convention, because the temporary protection does not suspend states what we call duties under 1951 convention. And same is applicable in case of 9 core international human rights treaties framework obligations. State parties to 1951 convention or state parties to the 9 core international human rights treaties, or state parties not in the what we call stricto sensu, but in a state of lato sense, they are under an obligation under customary international law to protect refugees. And therefore, my dear friends, temporary protection should not become a substitute for the right of refugees to seek and enjoy asylum in accordance with international agreed standards. This reminds me of a very, very important provision which I have already submitted for your consideration, and that is Article 14, Subclause 1 of Universal Declaration of Human Rights. The mandate, even in case of extended temporary protection, should not be forgotten, and we should also resort to the standards set in Universal Declaration of Human Rights. Therefore, my dear friends, temporary protection is widely regarded as an international legal norm. temporary protection is now obligatory in certain specific circumstances on states, particularly with regard to their treatment of a mass influx of refugees or of persons fleeing situations of armed conflict or civil strife in their country of homeland, in their country of origin. As a recognized status, my dear friends, it is the most recent of three major possibilities for protection of what we call refugees a state can offer. The other two being the now universal obligations of non-refoulement. It means the non-return of a person to the land of what we call of danger, and it is generally the country of origin, and the non-obligatory protection of political asylum. My dear friends, a temporary protection as a prelude to repatriation involves issues analogous to those that arises under Article 1C subclause 5 of the Convention Refugees. Therefore, in these kinds of situation, my dear friends, the temporary protection has no accepted meaning under international law. Temporary protection, my dear friends, has acquired multiple and varied meanings depending on the context and the country or the situation that demands the invoking of temporary protection. So it should not be taken that there are certain important, but under all circumstances it should be treated as an international legal norm, because the temporary protection is a concept commonly used to describe a short-term emergency response to a mass influx of asylum seekers. And in that very situation, we should try to what we call understand this idea of temporary protection, because the temporary protection has also been applied, my dear friends, in situations where it is difficult to distinguish between asylum seekers and other moving in mixed what we call flows, as well as to broader categories of persons who fall outside the mandate of 1951 Refugee Convention, particularly under the convention definition of a refugee. Therefore, the term is often used interchangeably with temporary asylum, temporary refuge, temporary protection, and so on and so forth, when there are there happens to be a persons of what we call the similar situations or the similar what we call or identical sobriquets we can also what we call subscribe to. Therefore, this reminds me of a very, very important scholar, Mr. Coles, C-O-L-E-S. He has written a lot, particularly in 1980s. He has also, came out with certain important, observations on temporary protection. Because the Coles has preferred not temporary protection. Coles has used a very, very important, expression which is within inverted commas, which is known as temporary refuge, instead of using temporary asylum or temporary protection. Largely because, as he has argued, my dear friends, he wanted to avoid any kind of a he deliberately preferred the word refuge instead of asylum, just to avoid any sort of confusion. He defined temporary protection as temporary refuge. And he says, I quote, that protection characterized by the principle of non-refoulement, which is accorded a person and which is temporary pending the obtaining of a durable solution, unquote. Then there is another important, scholar. I am talking of the Hartman, Hartman. He was also of the view, and he equated the idea of, at the same time, particularly in 1980s, he also came out with the idea, with an understanding of the temporary protection. And he equated the idea of, temporary refuge with the traditional refugee law concept of non-refoulement. And I quote, that temporary protection consists essentially of a ban on forced repatriation of civilian war victims, and also notes that its temporary limits are determined by the duration of the armed conflict, which can persist for extended periods or flare up only briefly, unquote. So these observations, if you take into account, the word temporary refuge, it has become coterminous with the duration of the armed conflict in the country of origin. If armed conflict is going on, as long as armed conflict is, there in the country of, origin, then it is going to be the period of the temporary protection in the host state. So you can very well understand, my dear friend, that the temporary refuge has crystallized into a customary international law norm, because practice of granting sanctuary to civilian war victims is well documented and is, my dear friend, maintains the consistency to the extent of these, developments. Many modern temporary protection arrangements include, my dear friends, some form of, rights enjoyment. As I have, submitted that the temporary protection is basically a precursor to a range of rights. Basically, when refugees are going to enjoy rights, they are basically enjoying protection. If in ordinary circumstances, the governments are making available all sorts of rights, rights, then basically the governments have been undertaking certain important steps, ensuring the protection of their, citizens. Because I am of the view, when we are using two important words of protection and rights, if rights are protected or the protection is, provided, basically what host states have been doing, or the national government is, doing, they are basically ensuring the enjoyment of rights. Because the language of temporary protection, my dear friends, emerged in the 90s. As my dear friend has also, pointed out, I am talking of Mr. Imran, that the language and the semantics, the entire lexicography of temporary protection emerged in 1990s, as the shift in language from refuge to protection appears to have, coincided with the transition in the meaning of international protection that also took place at this particular what we call, time, and this is a what we call, decade, which is known as 1990s. So you can very well understand how refuge has become protection. It means if Mr. A has given shelter to Mr. B in his country or in his, rule, in the ordinary, circumstances, that amounts to protection. And there have been, situations in case of what we call generalized violence in the ordinary, circumstances. in case of massive violations of human rights, in case of mass influx of what we call of refugees, as we have witnessed during 1947, the partition period in South Asia. We have witnessed subsequently in 1971 at the time of the creation of a new state called Bangladesh today, or in case of what we call driving out of Tibetan people in 1959 out of Tibet by China, and they took shelter in India. Tamil refugees, because of armed conflict in Sri Lanka, from the Jaffna Peninsula, lot of entire what we call once the Tamil population took refuge in India. Internally displaced persons, because of conflicts, because of communal rights, because of racial rights, because of linguistic rights in South Asia, many people moved from one place to another place within their own country. Therefore, we should not forget that there has been a paradigmatic shift from refuge to protection. And that has been what we call, recognized. Even the later transition, my dear friends, saw a shift from a focus on diplomatic, what we call, protection, to a broader concept of the international protection. The later invoking human rights, or which is popularly known as, my dear friends, as surrogate, what we call, protection. Similarly, temporary protection appears to move beyond, Coles or Hartman's what we call, non-refoulement obligation to other limited human rights, what we call, protection. Therefore, my dear friends, in 19, what we call, once again, I take you back to the UNHCR, not on international protection, where the international protection has been provided a full-fledged what we call description in 1994 by the United Nations High Commissioner for Refugees. And I quote, my dear friends, temporary protection as a means in situations of mass outflows for providing refuge to group or categories of what we call of persons recognized to be in need of international protection without recourse, at least initially, to individual refugee status determination. It includes, my dear friends, respect for basic human rights. But since it is conceived as an emergency protection measure of hopefully shorter duration, a more limited range of rights and benefits offered in the initial stage than would customarily be accorded refugee granted under the 1951 Refugee Convention, along with its additional protocol of 1967, I end quote. So this is how in 1994, even UNHCR has also clarified. So you can very well understand, my dear friend, understand how the idea of temporary protection came into existence. But at the same time, my dear friend, this is going to be my humble submission to all of you, that there are certain important steps which have also been what we call taken, particularly in the year 2000. In the month of June 2000, if you take into account, then UNHCR came out with the idea of what we call the complementary protection. From temporary protection to complementary protection in the year June 2000. Because in this particular, note of the June 2000, particularly while emphasizing the importance of complementary protection, UNHCR was of the view that a number of asylum countries have in place administrative or legislative mechanisms for regularizing the history of persons who are not formally recognized as refugees, but for whom return is not possible or advisable for a variety of reasons. Therefore, it is a positive way of responding pragmatically to certain international protection needs, and the idea or contemplation of the complementary protection is one of them. In the absence of any kind of harmonization, in the absence of individual responses by the states, have ultimately led to a proliferation of statuses granted to a wide range of persons for various reasons. And there are certain important examples as well, my dear friends. Examples of these different types of status include B status, subsidiary protection, de facto status, and humanitarian status. Varying standards of treatment with corresponding consequences for the beneficiary are attached to these kinds of statuses. Therefore, if you take into account the range of what you call of the beneficiaries of the complementary form of protection to provide some analysis of the legal what you call framework applicable to them, or people who have become the beneficiaries of the complementary protection, and the nature of protection provided by the state is equally important. And that, my dear friends, suggest that the appropriate standards of treatment, which from UNHCR's perspective should be in place, whether it is known as the surrogate protection, whether it is known as the some other kind of protection. If you take into account a review of the various categories of persons who benefit from relaxation, who benefit from relaxation, I mean extended by the host state, permission extended or granted by the state, host state, for a prolonged period of stay, reveals, my dear friends, that it is granted by states for a whole range of reasons, of which only, my dear friends, some are related to a need for international protection. Reasons can be roughly categorized, my dear friends. Number one, those which are purely compassionate reasons, or the reasons or the grounds of compassion, or based on practical considerations. Number two could be, my dear friends, so those which are related to international protection needs and may thus qualify as complementary form of protection. The focus of the complementary protection is basically the protection which is available to the ordinary citizens in the host state, or the citizens of the host state must also be extended on a limited scale to the new arrivals of refugees. Because stay requires of the new arrivals or the new influx of refugees that they should also enjoy the same kind of a sense of protection which is available to the citizens of the host state. Because the compassion, humanity, or human equality are the moving grounds, moving spirit upon which such kind of what you call of protections are generally enjoyed. When we are talking of the prolonged stay, my dear friends, and that too upon compassionate reasons, what may be the reasons like age factors, medical condition, family connections, family reunification, reproductive rights of women situation, child rights, particularly the girl child situations. These are, these grounds require some kind of a compassion, and that is why we require the idea of complementary protection. Therefore, in these circumstances, in the year 2001, United Nations High Commissioner for Refugees refocused on the influx and reiterated its view of temporary protection. The idea of the temporary protection has been best, reconceptualized as a practical, device for meeting urgent protection needs, particularly in situations of mass influx. Its value in ensuring protection from refoulement and basic minimum treatment in accordance with international human rights treaties without overburdening individual state determination procedures, which had been what we call, demonstrated by the UNHCR. In this particular context, my dear friends, UNHCR has acknowledged that temporary protection can be applied to convention refugees in the emergency situations. And it is also permitted that the suspension of the both states' determination procedures and the full range of convention rights is a possibility. And therefore, my dear friends, UNHCR has never, however, elaborated the legal rather than the practical humanitarian basis for such kind of a suspension. So therefore, under all circumstances, my dear friends, temporary protections constitute a very, very important element in protecting refugees in the mass influx situations. I stop at this stage, and tomorrow I will complete, and I would be taking up one particular region in case of temporary protection, and that is the European Union Temporary Protection Directive. And we would be appreciating the further what we call notions and other what we call incidental forms of protections. So I stop here, my dear friends. If you have questions, you're most welcome, and rest of the submissions I would be completing tomorrow at the same time. So thank you very much. Yeah, thank you, Atasham Sahib.
Thank you, sir.
You're welcome, brother. You're welcome.
Thank you, sir.
You're welcome. Thank you. Thank you, Awal Sahib. Thank you, Mr. Shubham. Thanks a lot. Thanks a lot, Miss Tasneem, Miss Awal Khan. Imran Sahib, I will phone you today. So sometimes I try to, make a call to you, but I generally receive no response.
Even I wanted to talk to you, so I was about to call you after if that is fine.
Yeah, today we will talk. Today we will talk.
Okay. Yes, sir. Thank
Okay.
you, sir.
After at around 8:30, I will call you.
Yes, sir. Okay. Fine, sir.
Okay.
Assalamu
Thank
alaikum.
you. Islam. Thanks a lot for joining. Thank you.